one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, distinguished Chief Justices, Honourable Justices, esteemed colleagues and friends. I'm Dr. Nauman Reayat, founder and chief convener of the Global South Network and a lecturer in law at the Leicester Law School, University of Leicester. My research interests lie in judicial independence, compliance with higher judiciary, constitutionalism, judicial populism, and digitalization of justice systems. I will be moderating this session. Thank you all those who are attending this event online. I warmly welcome you to the third North-South Judicial Dialogue organized by the Global South Network as part of our Judges Guest Lecture Series. I would also like to extend my sincere thanks to all the distinguished discussants who have agreed to share their insights, and to all participants who are joining us online. Your engagement ensures that this session is not merely a lecture, but a truly transnational dialogue reflecting the very essence of the Global South Network. Before I proceed further, I would like to note that the bios of all participating judges have been circulated to attendees. In the interest of time, I will not go into the details of each biography, and I assume that you have all had the opportunity to read them. To maintain a safe, professional, and equitable online environment, I kindly request that audience members who are not speaking that submit any questions or comments via email. Please indicate whether you would like your contribution to be anonymous or provide your full name and affiliation. I will read these out during the question and answer session so that all voices can be heard. Honorable guests and attendees, in recent months and over the past year, judges and judicial institutions across the world have faced significant pressures. In Poland, the European Union's highest court ruled in December 2025 that the Constitutional Tribunal lacked independence due to questionable appointments. In Belgium, senior appellate judges warned a few days ago in March 2026 that organized crime was threatening judicial structures, requiring some judges to seek personal security. In El Salvador, a state of exception imposed to address gang violence has resulted in arbitrary detentions and constraints on due process, with dismissals of judges who opposed executive actions threatening judicial independence. In Zambia, Parliament adopted the Constitutional Amendment Act number 7 of 2025, despite a prior Constitutional Court ruling declaring it unconstitutional, raising serious concerns about political overreach and marginalization of judicial authority. Clearly, whether north, south, east, or west, the wave of the backsliding of the rule of law does not discriminate. Ladies and gentlemen, one of the proud promises of the civilized world has always been law, order, peace, and discipline. These ideals have long formed the basis on which countries were classified as developed or developing, majority world or minority world, first world or third world. Yet recently, even in some countries of the civilized world, we have witnessed instances where international law is disregarded and rule by law is preferred over the rule of law. This raises profound questions about the knowledge produced globally on concepts such as peace, order, stability, and the rule of law. It reveals gaps in understanding that can only be bridged if narratives, discourses, and stories from different parts of the world are produced and exchanged on the basis of equality. Such dialogue is possible only in an open, safe, professional, interdisciplinary, and trustworthy forum where individuals from different backgrounds can share knowledge and exchange ideas about good practices. The Global South Network is precisely that forum. I established the network in March 2023, and over the past 3 to 4 years, it has become the world's only international interdisciplinary platform for judicial and academic knowledge exchange. Between May 2023 and March 2026, the network has facilitated 150 knowledge exchange activities, including 4 international hybrid conferences and 130 weekly PhD in progress panel discussion seminars across different phases, bringing together scholars and practitioners from all over the world every week on Wednesday. The network has also developed 6 geographic chapters, including South Asia, Middle East, Southeast Asia, Eastern Europe, Africa, and Latin America, and 6 disciplinary chapters covering business, criminology, law, political science, and health, caring, and well-being. These achievements highlight the unique and transformative role of the Global South Network in facilitating judicial exchange and knowledge sharing globally. We have hosted 15 guest lectures delivered by Supreme Court judges from different countries and 2 judicial dialogues between the Global North and the Global South involving Supreme Courts from 17 countries. Today's dialogue on the backsliding of the rule of law is part of the guest lecture series. We are particularly privileged and honored to have as our guest speaker of today's dialogue the Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland. Justice Kuusiniemi has served as President since 2018, following a long and distinguished tenure as Justice of the Court, including leadership roles as Vice President and President of Chambers. Beyond his judicial service, he has had an illustrious academic career serving as Professor of Law at the University of Turku, holding visiting positions abroad, including at the University of Louisville in the United States, and authoring around 20 books and over 100 scholarly articles, primarily in administrative and environmental law. Equally important, and that's my, by the way, personal experience as well, Justice Kuusiniemi is admired for his humility, responsiveness, and collegiality. Those who have had the privilege of working with him will attest to this approachable and thoughtful nature, qualities that enrich every conversation and debate. In the interest of time, I will not go into further details of his biography, which I assume all attendees have already read. It is my great privilege to hand over the online floor to our guest speaker, the Honourable Justice Kari Kuusiniemi, who will deliver his lecture on the backsliding of the rule of law. Justice Kuusiniemi, on behalf of the Global South Network, our discussants, and all attendees, we warmly welcome you. The floor is now yours.
Nauman, thank you for all too kind introduction and your kind words. And ladies and gentlemen, to start with, I will express my deep gratitude to Dr. Nauman Reayat, who is founder and chief convener of the Global South Network, for creating a platform that does not simply celebrate consensus, but actively invites challenge, disagreement, and critical reflection. By bringing together judges, scholars, and practitioners from across the world, the network confronts how differently the rule of law is understood, applied, and at times undermined. I would also like to thank all the distinguished colleagues from several continents who have graciously agreed to participate in today's judicial dialogue. Your presence, insights, and commitment to the rule of law enrich this discussion immensely. This gathering would not be possible without your dedication, and we are deeply grateful for the time and expertise you bring to this conversation. It's a real privilege to speak in today's event, not to rehearse familiar narratives, but to question assumptions and engage with colleagues on a global issue that is anything but settled, whether the rule of law remains a lived reality or is increasingly becoming a rhetorical promise. I feel honored to share these reflections with you, but I do so with a deep sense of unease. The subject that brings us together today, the backsliding of the rule of law, is not an abstract concern of an academic trend. It is lived and accelerating reality, and one that should trouble judges worldwide. My concern is firmly grounded in recent global developments. Some of those were already mentioned by Dr. Reayat's introductory words. The World Justice Project Rule of Law Index 2025 reveals a stark picture. Nearly 68% of countries worldwide have experienced a decline in rule of law scores, with particularly serious erosion in constraints on government power and the protection of fundamental rights. This is not a problem confined to fragile states or emerging democracies. It is increasingly visible within established legal systems, including in Europe. Let me share some recent pieces of news from international media. From December 2025, mass protests in Bucharest, Romania, called for the resignation of senior judicial officials and sweeping reforms to safeguard judicial independence, following revelations of corruption at the highest levels of the justice system. In Hungary, critics argue that a decree issued on February 2026 ordering courts to drop ongoing cases against the government, including challenges to a controversial tax, has effectively overridden judicial authority and struck at the heart of judicial independence. Over the past year, several judges of the Supreme Court of Pakistan and the provincial high courts have either resigned or formally expressed concerns to the Chief Justice regarding the rule of law and judicial independence. Across the Atlantic, judges in the United States, whose jurisprudence has long shaped the global understanding of the rule of law, have faced threats of impeachment from the executive in direct retaliation for independent judicial decisions. These are only a few examples. Almost every country today confronts its own version of this crisis. Whether democratic or authoritarian, European or non-European, north or south, east or west, the erosion of the rule of law has become a truly global phenomenon. This compels us to ask uncomfortable but unavoidable questions. Why is defiance of the rule of law gaining political appeal across the world? Why is the rules-based international order under such sustained and coordinated attack? And most importantly, what can we as individual judges realistically do to resist this tide? The forces and issues judges confront are sometimes political, popular, and deeply polarizing. These conflicts inevitably arrive in our courtrooms, and when they do, the world is watching. Yet we are expected to remain apolitical, to stand firm when institutions tremble, to speak through reason when power shouts, and to defend principles that may no longer be fashionable. The question then is no longer whether the rule of law is under threat, but whether we are prepared to meet the threat with courage, restraint, and resolve. Paradoxically, it is institutions themselves that both protect judges from politics and expose them to it. Where institutions are clearly defined and robust, they shield judges from political entanglement. Where they are vague, incomplete, or unwritten, they demand a purposive judicial approach, one that may invite accusations of judicial activism or political interference. In either case, our judgments inevitably produce winners and losers, and criticism is unavoidable. There is no neutral refuge. It is institutions, written or unwritten, that shape shared values and determine how societies confront their most profound challenges. Allow me to begin with the discussion of institutions in the European context, which I am most familiar. The value foundation of the European Union is expressly articulated in Article 2 of the Treaty of European Union, which affirms respect for human dignity, freedom, democracy, equality, the rule of law, and human rights including the rights of minorities. These values presuppose a society marked by pluralism, tolerance, justice, solidarity, and equality. They are not aspirational slogans. They are binding constitutional commitments. The so-called Copenhagen criteria further reinforce this foundation. They require not only democratic institutions, respect for human rights, and a functioning market economy at the moment of accession, but, according to the settled case law of the Court of Justice of the European Union, their continuous observance throughout membership. This means that every member state has freely accepted the principle of liberal democracy, the rule of law, and human rights as permanent obligations. Against this backdrop, the notion of so-called illiberal democracy advanced by Prime Minister Viktor Orban is a contradiction in terms, one that is fundamentally incompatible with membership in the European Union. Although the rule of law is not exhaustively defined in the EU treaties, it is clearly presupposed. Among the most influential articulations is the Venice Commission's Rule of Law checklist, updated in December 2025. At its core lies a simple but demanding insight. Democracy, the rule of law, and human rights are mutually reinforcing. Without an independent judiciary, individuals lack effective remedies. Without effective remedies, rights become illusory. And where courts can be silenced or subordinated, executive power becomes unchecked. But courts do not operate in vacuum. Their independence can only function meaningfully within a broader ecosystem of accountability, one that depends on transparency, public scrutiny, and informed citizens. The rule of law is therefore not sustained by judges alone, but by a wider constitutional culture that insists that power must always justify itself. This is why the principle that no one should be above the law is inseparable from the existence of independent and pluralistic media. Accountability must apply to all, especially those who govern, and without reliable information, the public cannot hold power to account. In an era of disinformation, cyber manipulation, and hate-driven narratives, free, independent, and responsible media are indispensable to democratic choice. Where citizens are uninformed, elections lose their meaning. Where scrutiny weakens, power hardens, and history shows that when scrutiny fades, the judiciary is often the next institution to come under pressure. The warning signs are no longer theoretical. Across Europe and beyond, courts have been targeted through court packing, forced retirements, disciplinary chambers, punitive transfers, and restrictions on judicial dialogue with supranational courts. The European Court of Human Rights has condemned blatant violations of judicial appointment procedures, including a Grand Chamber judgment against Iceland, where merit-based selection was openly disregarded. History reminds us that these tactics of court packing are not new. Even Franklin D. Roosevelt famously threatened to expand the US Supreme Court to secure political approval for the New Deal. But long before that, As Emma Southon recounts, the Roman king Tarquinius doubled the Senate with loyalists to entrench his power. Vestigia terrent, the footprints warn us. What these examples show is that the erosion of the rule of law rarely begins with tanks or coups. It begins with technical adjustments, procedural shortcuts, and narratives of efficiency or popular will. And it often ends with judges standing alone, asked to uphold principles precisely when doing so is most costly. That is the moment we must be prepared for, because if judges retreat when pressure mounts, the rule of law does not merely weaken, it collapses quietly from within. And this danger is not confined to fragile systems. It can unfold just as easily in long-established democracies as in openly authoritarian regimes. It is precisely for this reason that developments in the United States deserve close and sober attention. For decades, the United States has been seen as a lighthouse of democracy, constitutional freedoms, equal opportunity, and judicial independence. Its courts have long set global benchmarks, shaping how the rule of law is understood far beyond its borders. Yet today, even lighthouses can flicker. Recent developments during Donald Trump's second term have raised serious questions about the resilience of American democracy and the rule of law. I will confine myself to a single source, an editorial opinion published by the New York Times on 1st November 2025, entitled "In Trump's America, Are We Losing Our Democracy?" I'm of course fully aware that the New York Times is ideologically extremely distant from MAGA Republican thinking. That, however, does not relieve us of the responsibility to engage seriously with the arguments presented. The editorial board identified 12 markers of democratic erosion. They did not claim that the United States has become an autocracy akin to Russia or China, but they warned, crucially, of a slide towards authoritarianism. Among the indicators they listed were the suppression of dissent, persecution of political opponents, bypassing of the legislature, defiance of courts, misuse of emergency powers, vilification of minorities, control of information, pressure on universities, cultivation of a cult of personality, personal enrichment through power, and manipulation of law to retain office. These indicators are not abstract warning signs. They require meaning only when we ask how far they translate into practice and whether existing constitutional safeguards are strong enough to resist them. Time does not permit a detailed discussion of examples, but none of us who follow the news seriously can pretend ignorance. What remains uncertain is whether the American system of checks and balances will ultimately prevail. The president has not so far openly defied rulings of the Supreme Court. Yet recent scholarship, including work of German constitutional scholars, suggests that observance of a conservative majority court may in sensitive cases show increasing deference in interpretations aligned with executive agenda. That alone should give us pause. But the very recent Supreme Court judgment on tariff provides hope for the future. At this point, a clarification is essential. Neither United States nor the European Union member states previously discussed, such as Hungary and Poland, are dictatorships. No. They hold elections. Opposition parties exist. Political competition is not abolished. But, as said, democracy does not collapse overnight. It erodes incrementally through gerrymandering, media pressure, selective party financing, and the instrumentalization of law. Elections may remain, while their fairness is quietly hollowed out. Why, then, focus so intently on the United States? Not only because it remains the world's sole superpower led by the most powerful individual on the planet. What matters just as much are its evolving security and foreign policy doctrines, and, in particular, how Europe is perceived within them. The current US administration has openly criticized the European Union for liberalism, migration policies, climate action, and minority rights. It has also explicitly supported European governments and movements that share its worldview. These positions do not remain confined to rhetoric or diplomacy. In an interconnected political environment, they travel quickly across borders and translate into influence on domestic debates within Europe itself. These consequences are tangible. Political parties and movements in Europe now receive ideological and sometimes material support from overseas for agendas that sit uneasily with EU values and member state commitments referred to earlier. The old Cold War divide between capitalism and communism has faded. The new fault line is different. One influential framing is the so-called GALTAN divide, meaning green, alternative, liberal versus traditional, authoritarian, nationalist. This is not merely a cultural clash, it is a constitutional one. Seen through this lens, the rise of autocratic national conservative movements becomes easier to understand. Often described as populist, their defining feature is a direct appeal to the people, coupled with deep suspicion toward institutions, especially courts. They reject a core premise of the rule of law. Democracy is not a dictatorship of the majority. Human rights do not depend on opinion polls. It is precisely at this point where majority will collide with constitutional limits that independent courts become both indispensable and acutely vulnerable. This vulnerability is further intensified by political polarization. Even societies with strong liberal traditions struggle with political discourse shifts toward extremes. The challenge is real. How do we defend liberal democratic values, those embedded, for instance, in Article 2 TEU, without drifting so far into abstraction that they lose the confidence of the majority. This tension is not hypothetical. It defines our moment. And it is because this struggle is so widespread and unresolved that its consequences are now visible far beyond any single country or region. Globally, the rule of law is not merely backsliding, it is in danger of free fall. As mentioned at the outset, rule of law scores have declined in most countries for at least 7 consecutive years. According to the Finnish Rule of Law Center, more than 5.7 billion people now live under autocratic regimes, and 1.5 billion lack meaningful access to justice. Rising authoritarianism and weakening judicial independence are central drivers of this regression. These developments leave little room for complacency. The rule of law is under attack across the globe. In some countries, it has so far been successfully defended, but even there it remains vulnerable and fragile. The rule of law is not self-executing. It cannot be taken for granted. If it is to survive, it must be consciously protected and, when necessary, actively defended. What strikes me most is how frequently large segments of the population are drawn to authoritarian, nationalistic, and conservative currents, even when the empirical evidence speaks so clearly against them. This is all the more puzzling when we turn to decades of rigorous economic and institutional research demonstrating that societies governed by the rule of law consistently outperform those that are not. Countries that score highest on the rule of law indices, such as Denmark, Norway, and Finland, are also among the most prosperous, stable, and yes, happiest societies on earth. This is not coincidence. It is correlation with causation. The lesson is unmistakable. When the rule of law weakens, prosperity, trust, and freedom follow it down. However, I do not suggest that Finland is free from rule of law challenges. For example, court proceedings can be excessively lengthy, and the prevalence of domestic violence remains deeply concerning. There's always room for improvement. Societies marked by the weak institutions and extractive governments do not generate sustainable growth or genuine social progress. This insight has been powerfully articulated by the 2024 Nobel Prize laureates in economics, Darren Acemoglu and James A. Robinson. In Why Nations Fail, published in 2012, and The Narrow Corridor, 2019, they show through history, data, and comparative analysis that prosperity flows from inclusive institutions built on trust, accountability, and the rule of law. Where institutions are extractive, designed to benefit those in power, societies become trapped in stagnation. And yet, despite this knowledge, the global trajectory is moving in the opposite direction. Authoritarianism, nationalism, and populism are on the rise. Institutions are openly despised. The naked exercise of power is admired. A rules-based international order is increasingly replaced by a deals-based one. Minorities and women are exposed to hostility rather than protection. This forces us to ask uncomfortable question. Is the liberal rule of law based vision of democratic society merely under strain, or is it at risk of being abandoned altogether? If this diagnosis is correct, the next question becomes unavoidable. How can the rule of law be secured for the future, and what concretely can judges and court presidents do? History offers a stark answer. One of the most reliable routes to authoritarian consolidation is the capture of apex courts and independent media. Once constitutional courts and free press fall under executive control, effective checks and balances disappear. This strategy is no longer theoretical. Its footprints are visible in multiple jurisdictions. Yet this is not the only path available. Some countries have chosen a different path, acting before the fire starts. In several Nordic states, including Norway, Sweden, and now also Finland, we are following a path to strengthen the constitutional guarantees for independence of courts, for instance. Of course, the most fundamental defense of the rule of law remains everyday judging. Integrity, impartiality, transparency, careful reasoning, timely justice. Courts defend the rule of law not through rhetoric, but through the quiet discipline of principled decision-making day after day. Yet new and troubling threats are emerging. The United States has imposed sanctions on judges and prosecutors of the International Criminal Court for carrying out their statutory duties. These individuals were effectively cut off from banking and essential services linked to US-based companies. European judicial associations rightly condemned this as an extreme form of pressure on an independent court. But the chilling effect may go further. Can we be certain that national or European judges will feel free to decide cases impartially when powerful foreign interests are involved? This is not a marginal issue. It strikes the very heart of judicial independence. In the European Union, unity in defense of shared values is not optional. It's a constitutional necessity. In a turbulent world, adherence to the rule of law is not only a legal obligation, it's also the most reliable path to prosperity, trust, and social cohesion. If proof is needed, we need only look at Estonia. In a little more than 3 decades since regaining independence, it has risen into a top tier of global rule of law rankings. Estonia's success demonstrates that even against daunting historical odds, a deliberate commitment to institutions, trusts, and legality can deliver remarkable results. That is the hopeful note on which I would like to end. The rule of law is fragile, but it's also powerful. And when defended with foresight, courage, and integrity, it remains one of humanity's most successful inventions. And it's precisely because the rule of law is both fragile and powerful, platforms for dialogue, reflection, and mutual learning matter more than ever. And this is why this platform, governed by Dr. Reayat, is so very precious at this very moment. And for this vision and for the tireless effort required to turn it into reality, my sincere thanks go to Dr. Nauman Reayat. His commitment to fostering genuine exchange among judges, scholars, practitioners, and societal actors has created not just a network, but a community. I look very much forward to hearing the responses of my esteemed colleagues from across the world. Thank you.
Many thanks, Justice Kuusiniemi, for delivering such an insightful and thought-provoking guest lecture. Your reflections on the law, judicial reasoning, and the broader role of courts in society have provided us with a deeper understanding of the principles that guide modern jurisprudence. Your experience and perspective have enriched this gathering, and we are truly grateful for the time and wisdom you have shared with us today. Before I go to the discussants, let me remind you that if you have any questions, concerns, or any comments you want to put forward to the Honourable Judges, please feel free to send that to me at my email address. Mics and cameras will remain disabled to ensure safe, equal, and inclusive online environment. It's now my great pleasure to go to South Asia, one of the most important jurisdictions of South Asia, Sri Lanka, to invite the Honourable Justice Dilip Nawaz of the Supreme Court of Sri Lanka to offer his response to the guest lecture and share his reflections on the themes that have been presented. Justice Nawaz, over to you.
Thank you very much, Doctor. Rule of law, as Dicey articulated in the year 1885 in his famous book, today has its echoes and resonance in Sri Lanka in full plenitude. We have developed subsets of rule of law in various themes based on the constitutional discourse. Now, we have had since independence in 1948 three constitutions. All those three constitutions sought to achieve in some way or the other the conception of rule of law in full measure. Now, our 1948 Constitution, if you take it from its inception, since the independence was granted to us in 1948, had this implied judicial review, a judicial review of legislation that was even affirmed to be so by the Privy Council, which was in existence for our appeals from this part of the country. Then we had the 1972 Constitution. As I said before, we have had three constitutions. In 1972, that model of judicial review of legislation, an aspect of rule of law, if I may call it that way, went out of the Constitution. There was this retrograde step taken to move away from judicial review of legislation. That continues even under the current dispensation of the 1978 Constitution, the third and final constitution we have had so far. So now the point that has been raised as contentious in this country is why judicial review cannot form once again the basis of our constitutional discourse. So this is one aspect of rule of law that has bothered us. Even India has asked us as to, recently I was in conversation, we were in conversation, and this question was posed to us as to why Sri Lanka does not have post-enactment review of legislation. That in a way would have promoted, according to critiques and advocates of rule of law, a sense of comfort as far as rule of law is concerned. Maybe in the future, these themes may be explored in Sri Lanka. Apart from that, in the allotted time that has been given to me, let me touch some of those rule of law developments. Now, this rule of law as conceived by Dicey, as I said, has undergone several changes, the contours of change. One such contour is access to justice. And how access to justice can alleviate arbitrariness in executive actions. If you look at the panorama or spectrum of cases that have been decided by the Supreme Court of Sri Lanka, you could see how the Supreme Court has been robust, despite the stresses and strains in the past, robust enough to advance this conception of rule of law in Sri Lanka. I would cite before you a particular instance of a case a case which really matters to all of us when we developed what was called a constitutional tort in this country. In other words, the constitution imposes duties on the part of the executive. When the executive, such as the head of state, falls out of the expected standards of behavior as far as the constitutional duties are concerned, the Supreme Court of Sri Lanka about 2 years ago imposed a higher requirement. In other words, it found the former executive of this country liable for breach of duties, constitutional duties, and thus a palliative reparation was ordered when a large number of victims in a bomb blast, of course caused by terrorists, came before the Supreme Court and then alleged before the Supreme Court that it was the executive at that time, along with some high officials who may have caused, or rather led to, the atrocities that we witnessed about 2 years ago. So the victims who were affected by this incident of bomb blast right around the country came before the court and then alleged constitutional breaches. In other words, at that time, the president of the country was also invested with the powers of security over the nation. And since the terrorists unleashed violence on unsuspecting churchgoers on the Easter Sunday, and so much damage to property and lives was caused, the victims cried for justice in the Supreme Court in the fundamental rights jurisdiction. In other words, the allegation was that the breach took place in the hands of the executive. So the Supreme Court was in a dilemma as to how a violation of a fundamental right can give rise to compensatory regime. So in the process, we looked around and we found constitutional tort as a device to hold the executive liable, and that is how I would say rule of law has been advanced in its full plenitude in Sri Lanka. Following that welcome decision, there was also a famous decision on economic mismanagement. That mismanagement was also alleged before the Supreme Court by citizens of Sri Lanka. Some of them came before court and said, well, the economic regression that was haunting Sri Lanka, and its aftermath is still being felt in Sri Lanka, was caused by mismanagement on the part of the heads of state and others at that time. The court vigorously borrowed this principle from the earlier decision of the Easter Sunday judgment and transposed on that in this particular case, and went on to pronounce reparations on the part of the wrongdoers who were at the helm of the state at that time. So you could see how principles of arbitrariness or principles of rule of law were sort of merged together so as to strike a balance for the benefit of the people. The last case which I would like to cite to you was one such case of non-holding of elections. When executive said it was a polycentric decision because the budgets were constrained and therefore we cannot hold elections, the Supreme Court ordered funds must be allocated for the holding of elections. Another great sign of advancing rule of law in Sri Lanka. So I would conclude by saying whenever backsliding is noticed, the courts, the judges always found it a greater obligation to uphold the rule of law. That is where I would rest my case. Thank you.
Thank you very much, the Honourable Justice Dilip Nawaz from the Supreme Court of Sri Lanka, for delivering this very insightful response. It's now my great pleasure to invite the Honourable Justice Dr. Omar Joaquin Barreto Suarez from the Council of State of Colombia to deliver his response to the guest lecture.
Thank you. Good afternoon. Honourable Justice Kuusiniemi, Dr. Nauman, the distinguished judges, colleagues of the Global South Network. It's an honor to participate in this conference from Colombia. The questions that bring us together is urgent. When the rule of law faces institutional challenges, what do the courts do? I'm going to respond with the specific experience of the Council of State of Colombia. What is the Council of State? The Council of State is the highest court in matters of administrative law. It was created more than 200 years ago in 1817, taking as reference the model of the French Council of State. For this reason, we share the same double function, to be consultants to the government and to be judges before it. For many decades, its function was exclusively consultative. It was only at the beginning of the 20th century that it also assumed the jurisdiction function. With this summarized resolution of disputes that arise between the state and individuals. It is divided in 5 sections that resolve issues in different areas, like labor, contractual and non-contractual liability of the state, tax, electoral, and a chamber that resolves a wide range of disputes. The Political Constitution of 1991 protects the broad Charter of Fundamental Rights, and it's one of the most guarantee-oriented in Latin America. But a solid constitution is not enough. What makes the rule of law work is that the public powers are independent and their decisions are respected, even when they are against the government of the day. For this, I am going to give as an example 2 recent decisions that had an impact at the national level. First decision, the suspension of the minimum wage decree. In 2025, the national government issued a decree to set the increase in the minimum wage. It was a measure that affected millions of Colombian families. The problem was not the increase itself, but the way the decision was made, because Colombian law requires that the minimum wage be defined through a process of dialogue between the government, workers, and employers. But the government didn't take into account this procedure and acted unilaterally. Several lawsuits were filed against that decree, and the Council of State provisionally suspended the effects until the judgment is issued. This was due not because of the he opposed to the measure, but because in the rule of law, the end does not justify the means. A just decision made by the party that violates the law is still illegal. Second decision, the limit of a mechanism for citizen participation. Last year, the Council of State also had to decide on the scope of a forum citizen participation, called popular consultation, which is a question that the government asks citizens so that they can vote on the issue of national importance. The President of the Republic intended to consult the people about some legislative measures to reform the labor law without having the prior and favorable consent of the Congress to be able to carry them out. The fundamental question is universal and concerning all us present here. Does direct democracy also have limits? The Council of States was clear in deciding citizen participation is a fundamental right, but the procedure indicated that the political constitution be respected for it to be valid. Otherwise, democracy can become an instrument to ignore the very rules that sustain it. From dialogue to action, a proportional reflection. The challenge of this conference is really that Colombia knows one, and of which we have built concrete institutional response, an independent court with more than 200 years of history and decisions that reinforce the rules, even when that generates political discomfort. But the Colombian experience also teaches us that no court can defend the rule of law alone. Europe found a structural answer. The Association of Councils of State and Supreme Administrative Courts of the European Union. It allows European courts to share jurisprudence, exchange justices, and coordinate common response. This makes the dialogue a permanent structure. The global network of the South has no equivalent. There is the International Association of Higher Administrative Court Jurisdictions, of which Colombia has been founding member since the 1983, but we don't have our own regional space with a defined structure and periodicity. I wonder if this dialogue that the global network of the South couldn't be the starting point for something more permanent, a formal network of cooperation between the high jurisdictions of the global South, which allows us to learn from each other and give common answers to challenges that, as this conference demonstrates, are shared with us. The rule of law is not defended only with sentences. It is also defended with institutions that support each other. Thank you very much.
Thank you, the Honourable Justice Dr. Omar Joaquin Barreto Soares from the Council of State, Colombia. Let me invite next discussant, the Honourable Justice Ihor Tashutin, President of the Administrative Cassation Court, Supreme Court of Ukraine, to deliver his response to the guest lecture.
Dear colleagues, dear participants of the event, it is a great honor for me to represent the system of administrative justice in Ukraine and to have the opportunity to outline the stages of its development, as well as the role and activities of the Administrative Cassation Court within the Supreme Court. Administrative justice in Ukraine as a distinct branch of the judiciary began to take institutional form following the adoption of the Code of Administrative Justice of Ukraine in 2005. A major transformation occurred as a result of the judicial reform carried out in 2016-2017, during which the judicial system was reorganized and a new Supreme Court was established. To briefly outline the structure of the Supreme Court, it is the highest judicial body in the judicial system of Ukraine. It consists of the Grand Chamber, the Administrative Cassation Court, the Commercial Cassation Court, the Criminal Cassation Court, and the Civil Cassation Court. On the 15th of December 2017, the Supreme Court commenced administering justice in its new institutional structure. Since that time, the Administrative Cassation Court within the Supreme Court has been exercising cassation review in administrative cases and has also been a court of first and appellate instances in cases defined by procedural legislation. The principal mission of the Administrative Cassation Court is to ensure the consistency and uniformity of judicial practice, as well as to develop legal positions in the field of public law relations. On the 8th of December 2025, the meeting of judges of the Administrative Cassation Court within the Supreme Court elected me the President of the Administrative Cassation Court by secret ballot. The Administrative Cassation Court within the Supreme Court is structured in specialized judicial chambers responsible for distinct categories of administrative cases. The judicial chambers for cases on taxes, fees, and other mandatory payments, 12 judges. The judicial chambers for cases on the protection of social rights, 13 judges. The judicial chambers for cases on the electoral process and referendums, and the protection of political rights of citizens, 13 judges. Issues relating of the internal functioning of the court are resolved by meeting of judges of the Administrative Cassation Court within the Supreme Court. This meeting adopts collegial decisions concerning the organization of courts' work and the efficient administration of justice. As of the end of February 2026, the actual number of judges serving at the Administrative Cassation Court within the Supreme Court is 43. Allow me to briefly refer to several figures illustrating the court's workload. With regard to procedural activity in 2025, the Administrative Cassation Court received approximately 57,000 cases and other procedural documents, which accounts for more than 59% of the total caseload of the Supreme Court. This trend has remained stable throughout the operation of the renewed Supreme Court and demonstrates the significant role of administrative justice in ensuring the uniformity of case law and the development of consistent legal positions. Allow me to conclude with the following observation. Administrative justice in Ukraine is not merely a mechanism for dispute resolution. It is a sphere in which the resilience of the rule of law is tested on a daily basis. Today, the Administrative Cassation Court within the Supreme Court serves as an institution that shapes the standards of public administration, defines the limits of state discretion, and maintains a fair balance between the public interest and the protection of human rights. In the context of war and the ongoing transformation associated with European integration, administrative justice has become one of the key guarantors of legal stability. Professional international dialogues such as today's are therefore essential not only for the exchange of experience, but also for the gradual and consistent development of a common European legal space. I am grateful for the opportunity for participate in such a constructive dialogues. Thank you for your attention.
Thank you, the Honourable Justice Dashutin from the Supreme Court of Ukraine for delivering your response. Very insightful. Now allow me to invite our next discussant, the Honourable Justice Igors Strupis, President of the Supreme Court of Latvia.
Professor Reayat, distinguished colleagues, thank you for inviting me in this event, especially on such an important and acute topic. The decline in rule of law should never be ignored. And today it's even impossible to ignore it as the signs of decline are multiplying. And the keynote speaker has already shown us worrying facts about it, and we all know about those facts. Well, I hate being a pessimist. However, what bothers me the most is that today's world seems to be moving towards authoritarianism in general. And what worries me even more is that the erosion of the rule of law is not the problem itself. It's just a symptom of something broader. It's the erosion of democratic culture. We all see that civilized debate is more and more being replaced by shouting matches where arguments are substituted by ad hominem attacks Polarization and political tribalism seem to be normal methods and goals of today's politicians, and public discourse is becoming even less reliable. And this is particularly dangerous since even media outlets that were once considered highly reputable are no longer immune to polarization. And all it goes hand in hand with declining public trust in the state institutions in general. There have always been philosophical theories about ways of social development, and one that catches attention today, watching all these events and knowing a bit of history, is the so-called cyclical theory of history, be it Plato, Spengler, Toynbee, Turchin, etc. Notwithstanding all the shortcomings of the theory, the general idea seems to be quite plausible, as uncomfortable as it may sound, that every social order eventually produces conditions that undermine it. With a little bit of simplification, the cycle most often quoted is tyranny, monarchy, democracy, anarchy, tyranny again, and it starts all over again. Perhaps the most dangerous and faulty assumption is that democracy and the rule of law are permanent achievements, but history suggests otherwise. It all starts with small things. It's almost never a big thing coming. It starts with some small things, a sign of corporativism here, a little leeway for our own there, withholding a legitimate objection just to keep the comfortable peace by not annoying or offending anyone, etc. And as much as I hate to be a pessimist, I hate it even more to be a naive daydreamer. I do recognize that, unfortunately, our capacity as judges regarding this is rather limited. We can uphold the rule of law while holding the office, which, however safe it may be, it differs from country to country, is not entirely under our control. And we can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them. And those are our natural limitations. Therefore, I doubt that we, with our limited arsenal, can prevent the worst, should it come. But we can hold the line, hoping that the transitionary period will be short enough to recover with minimum losses. As ancient Romans said, si vis pacem para bellum. So we have to be prepared for the worst. So we in Latvia, we recognize it, and we are already preparing for the worst. Should the populists win in the next elections, or should any other problems regarding the rule of law should come. And we are doing this through initiating and carrying out legal reforms, strengthening the judiciary, the status of the Judicial Council. We are trying to reduce, and quite successfully, the role of the Ministry of Justice in administering the courts. We are also educating general public, giving lectures at schools, etc. In other words, we are building resilience required to bring the democracy back if necessary. We are also actively communicating with public, trying to raise the level of transparency of the courts, weeding out judicial corporativism, and promoting the ideas of justice, rule of law, and democracy. And it shows, while public trust in many institutions has declined, trust in the courts has risen from about 38% to 49% in the last 5 years. During the last 5 years, to about 12% increase. So it seems that we are likely doing something right, at least something. What I'm trying to say, in essence, perhaps the task of courts in difficult times is not to save democracy alone. That would probably be unrealistic, but we can do a lot if should it start, because the courts are the most stable. They are not directly subordinated to political processes. So in the conclusion, I would define our task to be simpler and harder at the same time. We, during those turmoil times, we have to preserve the principles of the rule of law long enough for democratic societies to rediscover their value. Thank you.
Thank you, the Honourable Justice Aylwell Strupe, President of the Supreme Court of Latvia, for delivering your response to Justice Kuusiniemi's lecture. Now allow me to invite our next discussant, and the Honourable Justice Evo Pilving, Chairman of the Administrative Law Chamber, the Supreme Court of Estonia, to deliver his response.
Good afternoon, or good morning, or good evening for everybody over the globe. Honorable Chief Justices, Supreme Court Presidents, dear Kari, ladies and gentlemen. First, I would like to thank Dr. Reayat for creating this forum and his generous invitation to contribute it. Dialogue between different constitutional traditions between North and South is needed today more than ever before. And special thanks, of course, to you, President Kuusiniemi, for your honest diagnosis and positive program. Indeed, what should we do to stop the erosion of the rule of law? I fully concur. Maintaining of democracy and rule of law requires constant hard work, even war in its most brutal form, as we must see it already 5th year in Ukraine yet. President Tashutin, I wish you all the best in your new position. And dear Kari, thank you very much for highlighting Estonia in a positive way in this context. Allow me to make few comments on this. Rapid reforms were the key for success of Baltic countries, both transition to market economy, privatization of state-owned enterprises, not for local oligarchs, but also opening the market for foreign capital. However, this all required reliable legal system. The rule of law did not emerge in Baltic states that time from a vacuum. We had experience in building democracy and constitutionalism from the interwar period. Unfortunately, we also witnessed the decline of the rule of law in Estonia even before the Soviet occupation in 1940. Constitutional developments in recent decades have been particularly influenced by the desire to avoid repeating the historical mistakes that once led to a return to autocracy. Estonia's first constitution was adopted in 1920. Its greatest flaw was extreme parliamentarianism. Too much democracy, if I may say so. Combined with the economic crisis, this led to an authoritarian coup in 1934. The 1992 constitution is significantly more balanced in terms of the relationship between parliament and the government. In my view, the current constitution strikes a good balance also between political power and the courts. In Estonia, the role of the Constitutional Court is fulfilled by the Supreme Court. It has broad powers, most notably the authority to invalidate unconstitutional parliamentary acts. Our catalogue of fundamental rights is extensive. However, the right to initiate constitutional review is limited. Although fundamental rights are protected in ordinary and administrative courts, a parliamentary minority, for example, does not have the right to initiate judicial review of laws. Such a right may work well in some countries, but in others, through the politicization of the judiciary, it has failed to provide protection against the erosion of the rule of law. Even worse, to introduce it now may turn to Trojan horse, dragging the courts directly and deeply into partisan struggles. The political parties would attempt much more likely to bring the court under their control. There are currently many threats to stable democracy in our region, primarily due to Nazi Russian widespread hybrid warfare. A very worrying trend is the increase in political attacks on judges for their work, which we have seen practically everywhere in the world: India, Kenya, Ecuador, Estonia, and last but not least, United States. Today, we must avoid any additional risk that could call the credibility and resilience of the courts into question. Instead of granting the courts maximum possible power, their independence should be strengthened and transparency increased. President Kuusiniemi gave us several examples. In Estonia, the government is expected to submit a draft bill to Parliament this week to replace the Minister of Justice's authority over the administration of the courts with that of the Judicial Council. The details are still under discussion. We are currently engaged in a debate over stakeholders who should be represented in the Council. Politicians must not interfere with the substance of judicial decisions, but the organization and financing of the courts is a democratic issue too, not merely a business of the judiciary. An absolute lack of political accountability for the administration of the courts might be dangerous. It could lead to underfunding. This could provide a pretext for much stricter control of the courts in the future. Here too, we must strike a balance and avoid extremes which could lead to even more painful reactions later on, just as the history teaches us. Thank you, dear colleagues. Thank you, Dr. Reayat, and everybody in our global audience. Keep safe, everybody, in these turbulent times.
Thank you very much, the Honourable Justice Haywood Pilbing, for delivering your response. Allow me to invite our next discussion, the Honourable Justice Professor Dr. Andras Berga, President of the Curia Supreme Court of Hungary.
Honourable President, Honourable Madam Justice, judges, esteemed participants, their professors, their colleagues, let me begin my contribution by thanking Dr. Nauman Reayat for creating the opportunity for this particularly interesting dialogue. This event enables us to exchange experiences and share our thoughts with each other. I listened with interest to the lecture delivered by President Kari Kuusiniemi, and what he said confirmed in general my belief that the importance of the judiciary remains unquestionable in the functioning of a constitutional state and in maintaining of rule of law, or the principle of Rechtsstaat, because this is more common in Central Europe. And of course, it's very, very important from the point of view of public trust. In this context, I would like to share some observations with you. I will not react to the issue of liberal or illiberal shape of democracy. I will not, because this is not a legal, and what more, not a jurisdictional, but it's a political issue. And in Hungary, judges are not allowed to express political views. This is one of our version, our way, how we interpret rule of law and separation of powers. The provision of our constitution called fundamental law on the independence of judges also emphasizes that judges shall be independent and subject only to the law, and no judge could be instructed in relation to our judicial activities. This regulation is particularly important and relevant in the light of recent misunderstandings in Hungary regarding the so-called solidarity contribution. Perhaps solidarity tax is much more common, but formally is not a tax, is only a tax like a contribution. In respect which it should be stressed that the Curia, the Supreme Court of Hungary, is a cassation court. Consequently, the Curia shall decide on a case only when it is referred to it, after it is concluded at the level of lower courts. And the Curia, as a Supreme Court, cannot instruct lower instance courts in their ongoing cases. So this is the reason why we couldn't react to this problem of solidarity contribution was, or how it was introduced in the Hungarian legal system, and the content which ruled that all the pending cases should be finished. So the Curia therefore did not take any position on this government decree. First instance judges referred this case, some of them to the European Court of Justice, others to the Constitutional Court of Hungary. It is a fact that an emergency government decree may contain, in general, provisions that can be contra legem, so can be in line with the laws, with the acts of the parliament, or praeter legem. And this was such a decree. It was an emergency decree. But whether it was constitutional or not, we will see. So the Curia, the Supreme Court, had no pro and no con opinion regarding this, because we didn't got any file from lower courts. If we got, of course, we will decide. Esteemed colleagues, if I started with this, in the following I will share very, very shortly or briefly some thoughts on two major topics related to the administration of justice: the case law uniformization. Dr. Reayat knows that this is one of my favorite questions, and the adjudication in electoral cases. As regards the case law and uniform application of laws, mechanisms that ensure consistency in judicial practice play a key role in legal certainty and predictability of the judiciary or of the judicial decisions. In this regard, Hungary applies a unique model based mostly on the continental or so-called continental legal tradition, but which also incorporates the logic of the Anglo-Saxon precedent system or stare decisis theory. We call this limited system of precedents. Some weeks ago, I had the privilege to present its functioning and details at this channel. The other question, what is just in these days our apex task, is the adjudication in election cases. It is interesting that even if I mentioned that the Curia, the Supreme Court, is mainly a cassation court, in the election cases, the Curia, the Supreme Court, is the first and last instance court. This is interesting. There are some countries which follow this model, but it's a special situation regarding other matters of law in Hungary. Electoral adjudication is difficult because it must demonstrate that law is capable of creating finality, and even the losing party may and can accept without viewing the court as an enemy. In electoral cases, this is very, very difficult. I used to say that practically the role of a court is to find the conflict between parties, to transform the social, family, commercial, or even political conflicts into legal debates. This is the main role of the courts. But of course, this is difficult in commercial cases where a lot of money is questioned. This is more difficult in family cases where the question is very personal, but it's also very, very difficult when it's regarding election where the conflict of the political parties is crucial for them. And we have to transform this conflict, which during the campaign, it's what you see if you open the internet, what happens in a country during the election campaign. And our role is to refine it, to domesticate it, like we did thousands of years ago with animals, to do it, to make it possible to have a debate on legal arguments and to try to achieve a solution, a decision where even the losing party, and party in double meaning, the political party and party in our trial, can accept it. So this is why these days are really difficult for us. But if we do it successfully, then we demonstrate that rule of law is not only a theory, but it's a part of the everyday existence in a constitutional state. So dear colleagues, this was my contribution, and I would like to thank again for creating this opportunity, and congratulations for the Global South Network to engage in dialogue. And as the president of the Curia, we are very proud that we are one of the oldest Supreme Courts in the continental Europe. We are always ready to cooperate in the different topics. Thank you very much for your kind attention.
Thank you very much, the Honourable Justice Professor Dr. Andras Varga, President of the Curia Supreme Court of Hungary, for delivering your response. And we are also proud of engaging you, having a collaboration with you consistently. This is the second time we are having you, so it's really refreshing. Allow me to invite our next discussant, the Honourable Justice Francis Delabote, President of the Administrative Court of Luxembourg, and the President of the Constitutional Court of Luxembourg, to deliver his response to Justice Kuusiniemi's lecture.
Colleagues, dear friends, thank you for inviting me. I'm talking to you from the very tiny Luxembourg. 2 points in my transmission. First point, international law and multilateralism. Luxembourg has known over its history, first as 19th century and first part of 20th century, that the only means of defense against these big neighbors was international law, were the treaties. We only could invoke the Treaty of Vienna 1815, having built the existence of our country, the Treaty of London 1839 having confirmed our independence, and the Treaty of London again 1867 having confirmed our independence, and above having declared forever our country neutral. These treaties guaranteed our existence. But in 1914, First World War, these treaties were ineffective as nobody guaranteed our neutrality. So for those countries who should occur to get neutral one day, pay attention. The other point is we were invaded in those times by our neighbor, who also was our economic partner. So pay attention on your partners as well. Second point, we got one big, let's say, lesson after World War II, where the same neighbor occupied us, everybody knows, and we went to join the multilateralism put into part by President Wilson First World War and continued by President Roosevelt after World War II. We were founding members as a very tiny country of United Nations and of all the big organizations as NATO, as OSCE, OECD, and all those. And we were a founding member of the first community which has brought us to the European Union, the Community of Steel and Coal in 1952. And on the 10th of August 1952, it was in Luxembourg that the high authority, la haute autorité, began his work. So we know about those. And we know also that for us, it's very simple. International law is always above national law. We are not only for multilateralism, we are also monists in that sense that international law normally prevails. That's lesson number 1 from Luxembourg. Lesson number 2, rule of law. We have a revised constitution entered into force on the 1st of July 2023. Article 1 is providing what already the ancient constitution said: Luxembourg is a democratic state. 1. Second, Article 2, Paragraph 2 says, this democratic state underlies the principles, in plural, of the rule of law. That's very new. And it has to be done in the respect, says the same article, of human rights. So we have a triangle, a magic triangle between democracy, rule of law, and human rights. But what is more interesting is that our Constitutional Court already in 2019, after referral of the First Instance Tribunal Administratif in a very, let's say, critical case of fiscal matter, exchange of information in fiscal matter, Directive 2011-16 and so on, in that matter had asked the Constitutional Court whether there would exist a principle of rule of law. And the Constitutional Court responded that such a principle was not in those times inscribed in our Constitution, but it was inherent to the articles saying that Luxembourg was a democratic state, Article 1, and Article 51 saying that we were underlying the regime of parliamentarian democracy. And so for us, and for our Constitutional Court, rule of law, the principle of rule of law, is inherent to democracy. Second, this principle was set as a fundamental principle, even non-written, and having a constitutional value. Third, this constitutional principle had under-principles of constitutional value, so it was a meta-principle from which derive other principles, and in that case, number 146, there were 2 principles announced which we needed in that case, were the principle of access to justice and the principle of effective remedy, recours effectif. A further judgment of the Constitutional Court of the 21st of January 21 said that also the principle of sécurité juridique, confiance légitime, and non-retroactivité were principles of constitutional value, deriving from the principle of the rule of law. And a third judgment of 19th of March 2021 said that the principle of proportionality was also a general principle of constitutional value, deriving from the principle of rule of law. So, still, we have now the principle of rule of law in the Constitution, and we have still the Constitutional Court being able to reveal principles of constitutional value deriving from the principle of the rule of law. Third point, and last point for me today, is that in Luxembourg, and it's opposite to what happens in our neighboring countries, the constitutional judges are not nominated by political powers. They are first, for 4 of them, designated in the Constitution itself, and for the 5 others, they are proposed by an assembly of 2 courts, the Civil Supreme Court on one side, Cour supérieure de justice, and the Supreme Administrative Court, which I have the honor to preside, on the other hand. And those 5 judges are so elected by the pairs. Till last year, the 2 courts in assembly had to propose a ticket of 3 candidates, 1, 2, 3, and theoretically the executive might have chosen But for 30 years, it never happened. They always took the first proposed. Last year, we changed the law, and last year it was said that there is only one candidate proposed, and the Grand Duke, under the counter-signature of the Prime Minister, has to nominate that candidate. So in Luxembourg, constitutional judges, and part of those are no political charges, not designated by politics, and are judges. Thank you so much.
Thank you very much, the Honourable Justice Francis de la Porte, Vice President of Supreme Administrative Court of Luxembourg and the President of the Constitutional Court of Luxembourg, for delivering your response to Justice Kuusiniemi's lecture. Allow me to invite the Honourable Justice Karel Simka, President of Supreme Administrative Court of Czech Republic.
Good morning, good afternoon, good evening, or good night for everybody watching this debate. It's a pleasure to be here with you, but the topics of today's session make me a little bit depressive. The rule of law, plurality, checks and balances, freedom of speech, and so on. We in the West take it for granted. But such comfort of life, we are rich and free at the same time, is in the history of the mankind a rare exception. I'm afraid that the people in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for them self-convenient and maybe a little bit boring. We have no big and attractive goals or targets for which we should fight. Big ideologies of the past are more or less dead because most of them had failed, for example, communism or extreme nationalism, or some of them partly won, for example, economic and political liberalism and the ideology of human rights. I'm afraid that Western societies are going to be extremely pragmatic and that we partly lose the feeling about our common political values. Everything is possible, even the basics of the constitutional order and fundamental values can be disputed, criticized, and challenged. Political and constitutional systems are losing their authority and are fundamentally criticized as kingdoms of elites which don't understand the needs of the people. Courts are as typical kingdoms of elites and as very fragile state institutions are so in a big danger. We have no hard power, no soldiers, no weapons. We have only the authority. And our authority is mostly rational, not charismatic, and only partly traditional. The offer of courts is to give the parties a rationally reasoned decision. We cannot offer emotional identification, love, or empathy. If the courts would offer that, they wouldn't be impartial. I think we should understand the changing atmosphere in our societies, but I cannot imagine that we as courts and judges should slide on this populist and emotional wave. We are the part of the system and live and die with the system. Our role isn't to be leaders of the revolution. It would be a betrayal of our constitutional role. I think we should stay rational and maybe we should try to speak more to the public about our work, our constitutional role, and about our usefulness for the people. We should be a little bit sexy, but stay calm and explain our role with rational arguments. Maybe it can be not enough, but I don't see any other realistic option. The rule of law does exist only if the people believe that it does exist and only if they want that it is so. I believe in the people and in their rationality. Thank you, dear colleagues, for the opportunity to speak at this forum.
Thank you, Honourable Justice Karel Simka, President of the Supreme Administrative Court of Czech Republic, for delivering your response to Justice Kuusiniemi's lecture. Now allow me to invite our next discussant, the Right Honourable Richard Wagner, Chief Justice of Canada.
Good day to everyone. I am delighted to participate in this guest lecture series. I wish to thank President Kuusiniemi for his insightful remarks and the Global South Network for convening this important event. As Chief Justice of Canada, I am pleased to share a few reflections on the rule of law and judicial independence. As we all know, the rule of law rests on constitutional text and formal guarantees. It also rests on democratic institutions. Like my colleague from Finland said, independent courts, fair decisions, and public confidence are essential. Courts do not defend the rule of law through rhetoric. They do so by deciding cases carefully, transparently, and within the limits of their role. As mentioned, the most recent statistics from the World Justice Project are worrying. For the 8th year in a row, the rule of law has declined in most countries, and this decline is growing faster. This is not surprising, based on what many of us have seen for ourselves. Around the world, there are attempts to politicize the courts, erode public confidence in our justice systems, and undermine judicial independence. Some leaders openly dismiss international law. One of the International Criminal Court judges mentioned earlier is a Canadian Justice, Kimberly Prost, who is subject to sanctions for simply doing her job. This is a clear sign that the rule of law is backsliding. In many countries, this backsliding has not happened suddenly. Rather, it emerged gradually with small shifts in institutional practice, public expectations, or respect for legal constraints. Because the backsliding can be subtle, it requires vigilance. Finland has done so very well. For the past 10 years, it has consistently ranked among the strongest countries in the world on the Rule of Law Index. It has stable institutions, independent courts, and sustained public trust. But the rule of law is not static. Even in countries with strong traditions, like Finland or Canada, progress cannot be taken for granted. Conditions can change, pressures can emerge, and public confidence can be tested. Independent, competent, and trusted judiciaries are needed to protect the rule of law every day. When courts explain their decisions clearly, apply the law consistently, and remain accessible, they reinforce the legitimacy of the legal system as a whole. If we look closely at the index, we see that other countries have improved their rule of law rankings. President Kuusiniemi mentioned Estonia. Brazil is another example. Countries such as Uzbekistan, Sierra Leone, and Malawi have also improved their rankings. This is very encouraging for all of us. It also reminds us that we can all do better, but only if we learn from each other. Countries with long-established institutions can learn from those undertaking reform. The reverse is also true. We can also learn from the lessons of those who came before us. My colleague mentioned the book, Why Nations Fail. I have also read it. The authors show that societies with a poor rule of law do not grow or change for the better. It gives some historical examples to illustrate this point. One of these examples is the glorious revolution of the 17th century in England. This period marked the end of absolute monarchy and the emergence of pluralist political institutions. Power shifted away from the unchecked authority of the Crown and toward Parliament, creating a system of shared and restrained governance. As part of this transformation, the judiciary gained increased independence. Courts were better positioned to apply the law impartially, free from royal interference. The result was greater predictability in the enforcement of contracts and property rights. Studies have since shown that this greater judicial independence had significant economic impacts. We would all do well in this climate to remember these lessons. This is where international forums become especially helpful. The Global South Network provides an important space to share experiences and learn good practices from one another. We simply need an openness to listen. The rule of law is stronger when we do so. In that spirit, thank you once again for this opportunity to share my thoughts with you today. Thank you so much. Merci.
Thank you very much, the Right Honourable Richard Wagner, the Chief Justice of Canada, for delivering his response. Now I invite the Honourable Chief Justice of Kenya, the President of the Supreme Court of Kenya, Martha Koome, to deliver their response.
Thank you for giving me this opportunity to share a few thoughts on the topic, backsliding of the rule of law. I am honored, greatly honored, to join you, although virtually, for this important lecture organized under the Global South Network Judges Guest Lecture Series. I want to begin by thanking Dr. Nauman Reayat for the invitation to offer brief reflections in response to the timely theme, backsliding of the rule of law. I also want to extend very warm greetings to Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland, and commend his great leadership in advancing principled judicial discourse at a moment when such conversations are both necessary and urgent. The discussion of backsliding of the rule of law is not abstract, because across jurisdictions we observe pressures on judicial independence. We observe contestation of electoral outcomes. We observe erosion of public trust in institutions. We observe shrinking of civic space and heightened political polarization. In certain contexts, colleagues, courts are criticized for what is seen as overreach, and in others for what is viewed as restraint. Yet, in each of these situations, the rule of law depends upon a judiciary that is independent, a judiciary that is impartial and constitutionally anchored. In Kenya, the 2010 Constitution marked a profound and transformative institutional reset. It is restructured the judiciary to enhance independence, accountability, and public confidence. The Supreme Court of Kenya stands at the apex of this architecture. The court, which is composed of 7 judges, exercises exclusive original jurisdiction in presidential election disputes, as well as appellate jurisdiction in constitutional and other significant matters of public interest. The decisions of the Supreme Court are final and binding, and it is entrusted with the solemn responsibility of interpreting and safeguarding the Constitution. Our court structure in Kenya reflects an intentional design to entrench separation of powers while fostering transparency and reasoned decision making. Hearings are conducted publicly, judgments are delivered with detailed reasoning, and dissenting opinions are welcome, acknowledging that constitutional dialogue often evolves over time. The openness is critical to sustaining public legitimacy, especially in politically sensitive cases. Kenya's Supreme Court has adjudicated matters that may offer insights to superior courts worldwide. Its presidential election jurisprudence, for instance, has demonstrated that courts can scrutinize electoral processes rigorously while maintaining institutional calm. In nullifying a presidential election in 2017, the Supreme Court affirmed that fidelity to constitutional procedure is not secondary to political expediency. That decision underscored a simple principle that the rule of law requires that even the highest office be subjected to constitutional scrutiny. Beyond electoral disputes, the court has developed transformative jurisprudence in areas such as public participation, devolution of power, environmental governance, and socio-economic rights. It has emphasized that constitutionalism is not static. Constitutionalism is a living project that demands accountability, inclusivity, and protection of the marginalized communities and vulnerable groups. Importantly, judicial courage must be matched with judicial discipline. Dear colleagues, guarding against the backsliding of the rule of law requires not only bold decisions, but institutional integrity, transparency, and fidelity to the law. Courts must avoid politicization and isolation. Courts must remain independent, yet responsive, and principled, yet attentive to the lived realities of the people they serve. In Kenya, we are also pursuing reforms under the social transformation through access to justice, following our blueprint to ensure that the rule of law is experienced by citizens and that the law and the justice services are accessible and meaningful. When the rule of law is only anchored in court decisions and not grounded in everyday lives of citizens, it becomes vulnerable. By strengthening alternative dispute resolution mechanisms, enhancing digital access, and promoting people-centered justice, we seek to reinforce the social foundation upon which the rule of law and judicial authority ultimately rests. Finally, on judicial cooperation among superior courts, at a time of global uncertainty, transnational judicial dialogue is indispensable. Judiciaries across the world face similar challenges in regard to climate change matters, digital governance, electoral integrity, and human rights protection. Therefore, these structured exchanges such as this and other judicial colloquia, clerkship collaborations, and shared research platforms can deepen collaborative learning. Such collaboration does not dilute sovereignty of each jurisdiction. It actually enriches jurisprudence. It also affirms that while our constitutions are national, the values underpinning the rule of law are universal. As I conclude, I must emphasize that backsliding of the rule of law is not inevitable. It can be resisted through principled adjudication, institutional vigilance, and solidarity among courts committed to constitutional governance. Once again, I want to sincerely thank Global South Network for convening this important dialogue and for the gracious invitation. My apologies, I could not make it physically due to exigencies of duty. But may our collective reflection strengthen our shared resolve to uphold the rule of law firmly, faithfully, and without fear or favor. Thank you, and may God bless you.
Thank you very much, the Honourable Chief Justice of Kenya, for delivering our response. And now I invite the Honourable Vice President of the Supreme Court of Spain, the Honourable Justice Dimitri Berber of Ayuda, to deliver his response.
Good afternoon, everyone. The President of the Spanish Supreme Court, Isabel Perelló, and I wish to thank Dr. Nauman Reayat for convening this dialogue to exchange knowledge and good practice on so fundamental a topic as the rule of law. It is a pleasure to share with you some thoughts from the brilliant lecture delivered by President Kuusiniemi, who I have had the fortune of knowing for many years. The world is at a historical crossroads marked by global challenges, and because of this, the defense of the rule of law must not be confined to national borders. Judges are the main guarantee of the rule of law, obviously not the only one. For example, in an area close to me, such as the European Union, the rule of law value would not be fully understood without the Court of Justice and, of course, without the national judges. From the Spanish perspective, the rule of law is not an abstract ideal either, because our Constitution of 1978 declares Spain to be a social and democratic state subject to the rule of law. These words emerge from a transition from the former and authoritarian regime to constitutional democracy because of a very broad social consensus. Sometimes the Rubicon of the rule of law is not crossed suddenly, but more softly, through multiple leaks, some imperceptible, which can sink the ship of the rule of law with its fundamental values. In recent years, Spain has also faced complex situations regarding the rule of law. Some of these have seriously impeded the effectiveness of the judicial response due to an inability to fill vacancies caused by retirement or death in the Supreme Court and other high courts for almost 4 years. The origin of this situation lies in the failure of our parliamentary system to renew the General Council of the Judiciary. In fact, the previous council, designed in 2013 with a 5-year constitutional mandate, remained in office until 2024, that is, for almost 11 years. Considering the situation, a 2021 law prohibited the acting council from making discretionary appointments, for example, to the Supreme Court, leaving 1/3 of its position vacant until February 2025, when the new council made the pending appointments. Hence, what is important is not the existence of tension, but the way the institution faced the conflict, as was the case in the well-known attempted secession in Catalonia, which culminated in a unilateral declaration of independence in 2017. It is also important that the new technologies cannot evade the judicial control. A judicial response is necessary, such as that provided in September 2025 by the Spanish Supreme Court, which ruled that the government must disclose the source code of the Bosco algorithm used to determine eligibility for the bono social, a public energy subsidy. Individuals affected by algorithm decision must be able to understand the basis of which public benefits are granted or denied. In doing so, the Court reinforced a fundamental rule of law principle. Public power, whether exercised by a civil servant or by an algorithm, remains subject to scrutiny, legality, and accountability. Across Europe, and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed. Destroying public trust in judicial independence for strategic or political reasons is a dangerous irresponsibility that can erode our freedoms. In this situation, it is legitimate to ask what is happening and how to face it. In my view, this situation can only be overcome through prudence, full respect for the separation of powers, and through the strong democratic quality of our societies. And in this context, dialogue takes on particular importance, not only through preliminary rulings within the European Union or advisory opinion on the Protocol 16 of the Rome Convention, but also by a horizontal dialogue like the one we are holding today thanks to Global South Network, which allow us to believe in a better world guided by the North Star of the rule of law. Thank you very much for your attention.
Thank you very much, Honourable Justice Dimitri Berberov Ayuda, Vice President of the Supreme Court of Spain, for sharing his comments. Last but not the least, allow me to invite the Right Honourable Datuk Seri Utama Wan Ahmad Farid bin Wan Saleh, Chief Justice of Malaysia, to deliver their response.
Assalamualaikum. The Right Honourable Chief Justices, the Honourable Justices, distinguished guests, ladies and gentlemen. A very good evening. Please allow me to express my sincere thanks to the organizer for the kind invitation to share briefly the Malaysian court's perspective on the rule of law, a principle that lies at the heart of every just society. As the saying goes, Rome was not built in a day. In much the same way, the backsliding of the rule of law rarely happens overnight. More often, it unfolds gradually, one small step at a time, through changes that accumulate quietly over the years. Sometimes it begins with the gradual weakening of the checks and balances that are meant to exist between the three branches of government. At first, such changes may seem minor, but as we all know, even small shifts, if left unattended, can slowly alter the course of things. We must also remember that the rule of law is not merely about following procedures. Substance matters just as much. Every legal power conferred by Parliament carries with it legal limits. It is impossible to reconcile unfettered discretion with the rule of law simply because the power was created through proper legislative procedure. When discretion is left without sufficient restraint, uncertainty may quietly find its way in. Public confidence in the legal system may begin to waver. In Malaysia, the Federal Constitution remains our strongest safeguard against any backsliding of the rule of law. The written Federal Constitution stands as the supreme law of the land, binding the legislature, the executive, and the judiciary alike. Unlike systems founded on parliamentary supremacy, the supremacy of our Constitution empowers the courts to strike down laws that are inconsistent with the Constitution. This does not mean that the judiciary stands above the legislature or the executive. Rather, it reflects the judiciary's constitutional responsibility to ensure that each branch of government exercises its powers within the boundaries set by the Constitution. The judiciary is not supreme either. If the government disagrees with the court rulings that declare its actions unlawful or unconstitutional, it is not without recourse. The government can leverage its parliamentary majority to amend the relevant laws or the Constitution itself, effectively overturning the judiciary's findings. In my view, the rule of law, constitutional supremacy, and the separation of powers are closely intertwined. The doctrine of separation of powers ensures that the judiciary remains independent, able to carry out its constitutional duty without fear or favor, and guided only by the law. Over time, through judicial interpretation, our courts have recognized that the rule of law forms part of the meaning of the word law itself, particularly under Article 5.1 of the Constitution. Article 5.1 provides that no person shall be deprived of his life or personal liberty save in accordance with law. But what does the word law mean in this context? Our courts have made it clear that law does not refer merely to written legislation. It also incorporates the deeper principles that underpin the rule of law. From the Malaysian perspective, the Federal Court has observed that a central element of the rule of law is the equal subjection of all persons to the ordinary law. And this is not absolute, as the King enjoys personal immunity under Articles 32 and 183 of the Federal Constitution. Yet, the King's powers remain constitutionally constrained, meaning the rule of law is not displaced, merely qualified. Just as importantly, the law must be capable of guiding conduct. It should be clear, reasonably stable, and applied equally to all. In other words, while Parliament may enact or amend laws, this power is not unfettered. Fundamental liberties guaranteed by the Constitution cannot be undermined lightly, and certain provisions, particularly those relating to the position of the Malay rulers, are afforded even greater protection against legislative interference. In short, the safeguards are very much in place. For a law to satisfy the requirements of the rule of law, certain basic characteristics must be present, though non-exhaustive. A. The law should be clear. B. It should be sufficiently stable. C. It should be of general application. D. It should generally operate prospectively. E. It must be administered by an independent judiciary. And F. It must respect the principles of natural justice and the right to a fair trial. The rule of law must not remain an abstract idea. It must find expression in real decisions and real cases. In Malaysia, the doctrine of proportionality serves as a key judicial tool in safeguarding constitutional rights under Article 8.1 of the Constitution, which guarantees equality before the law. This constitutional guarantee mirrors A.V. Dicey's conception of the rule of law. Whenever Parliament limits a fundamental right, the doctrine of proportionality is immediately engaged, requiring the state action to meet a three-stage test of sufficient objective, rational nexus, and proportionality, ensuring that the constitutional rights are not curtailed lightly. Dicey gave us the rule of law as a rigid structure, mainly premised on the absence of arbitrary power and equality before the law. But in the modern Malaysia, with the rapid rise of AI, complex administrative bodies, and global digital governance, the challenge to us is even greater. Our job today is not just to defend the rule of law, as Dicey wrote it, but to ensure that the law doesn't just rule, it must also serve. Distinguished guests, ladies and gentlemen, so how to arrest the backslide when you sense it coming? For one, never ever give up, as we are in a losing game of chess. Rest assured that the judiciary holds the final move. We do not seek to win a political match or recognition, but we are here to ensure that no player no matter how powerful, knocks over the board. That is how backsliding can be checkmated. In upholding the rule of law, the courts ensure that legislative and executive powers remain within their lawful limits. At times, this may create the impression that the judiciary stands above the other branches of government, but that is not the case. The powers of the courts are themselves subject to limits. Our constitutional system ultimately rests upon a framework of checks and balances, where each branch of government plays its proper role. I remain confident that the Malaysian judiciary will continue to stay the course in upholding the rule of law and ensuring that it remains a guiding principle of justice in our country. Only by this way can a potential backsliding be avoided. Thank you for having me.
Thank you very much, the Honourable Chief Justice of Malaysia, for delivering his response. I really enjoyed almost the world tour, global tour of backsliding of the rule of law. All said, all done. Allow me to invite our Honourable guest speaker, if the Honourable Justice Kari Kuusiniemi, President of Supreme Administrative Court of Finland, to deliver his reflections, if there is any.
Thank you, dear Nauman. Thank you so much for all your very valuable insights and comments. I really appreciate your feedback. I have made quite a lot of notes, but the time doesn't allow me to go into these, but I think it's more useful to engage in some discussion if you so wish. I make only one exception for, in my opinion, a good reason. So I would like personally greet President of the Supreme Cassation Court in the Supreme Court of Ukraine, Igor Dashutin, and congratulate you for your appointment. I had a very good cooperation with your predecessor, Mikola Smokovic, and I'm sure and convinced that we will continue this cooperation with you too in the framework of ACA Europe. But we had a very wide array of very, very thorough, profound comments, also including some very philosophical and rhetorically beautiful comments. So I'm afraid I'm not going to touch them upon in detail, but once again, please receive my great appreciation and thanks all of you.
Thank you very much, Honourable Justice Kari Kuusiniemi, for for sharing your reflections on the responses of our Honourable discussant. Now, without much ado, allow me to open the floor, the imaginary online floor, to the question and answer sessions. So I have received quite a few questions and comments, and I think the first question is from Rosa Maria Cajiga Morales, doctoral researcher in bioethics and public law, Abu Academy University, Department of Law, Turku, Finland. And the question is for the Honourable Justice Kari Kuusiniemi. So I'm a PhD researcher in public law and bioethics. What preventive measures can be taken at an early stage to prevent erosion of the rule of law, particularly to protect universities and other institutions from political or institutional pressure?
Thank you. This is an extremely timely and good question. So regarding the courts and judiciary, I think in Finland, just like in Norway and Sweden, we have now moved to amend our constitution with some provisions safeguarding the independence of judiciary, linking to the number of justices at the Supreme Courts, the mandatory retirement age, the appointment procedure, and the role of judicial council. But the more difficult is the part of your question linking to the universities. I could still refer to one article of my previous colleague, Mats Melin. It is in Swedish, but I presume that you are able to read Swedish. It was his lecture when he was appointed doctorate honoris causa at the University of Stockholm, and there he parallels beautifully the necessity of upholding the independence both of the highest academic teaching and the courts, but how we can safeguard it, it's an other and more difficult question. But I think one major message in my talk was that we have to be always vigilant and prepared. We have to try to find small signs of erosion, and if we are able to find them, so we should protest against them and try to explain why this can be destructive for the independence of both the universities and the judiciary.
Thank you very much, Honourable Justice Kari Kuusiniemi, for your answer. The next question is about so that is an anonymous question. On the request of anonymity, the question has been asked. And the question is about the international cooperation, given that different countries have different experiences and different legal frameworks, how one country can help other country tackle with challenges regarding backsliding of the rule of law. And it's an open question. I think it hasn't been specified for one country or another. I think anyone can answer.
I would like to refer to several of the commentators' excellent comments, where it was emphasized that upholding the rule of law is not only a national thing, but many of you very rightly pointed out that it's a common challenge over the borders. But of course, we have to admit that we have different countries, different societies, different constitutions, and my remarks, even if they were not completely limited to European circumstances and especially European Union, they are mostly reflected by the fact that I'm living in this kind of system and legal order, where we have in the Treaty of the European Union very clear obligations to uphold a system based on democracy, the rule of law, and protecting of human rights. So that's not a political question in that sense. So we have agreed so. Another thing is that if these values are not protected and upheld, then it's a good question how to proceed. But I think personally that international cooperation can achieve important results, as we had here the comment of Justice Barreto from Colombia. I would like to highlight that the World Law Congress was arranged in Barranquilla, Colombia, in 2021, and there the highest decoration of this organization was handed down to the people of Colombia for their struggle to try to uphold and make the rule of law even better. And also, I would like to mention the organization of the Supreme Administrative Courts globally, which is known by the French acronym AIHIA. There we have in the conferences always a possibility to discuss important matters regarding, for instance, the rule of law and learn from each other. So I think these are just examples of how we can learn from each other.
Thank you, Honourable Justice Kari Kuusiniemi, for answering the question. The next question, I think, is probably should be the last one, is for two countries, and it's a kind of a comparative question, and it's about Ukraine and Colombia. And the question is that the two courts operated in a context shaped by history of challenging political and social developments, kind of referring to the conflicts. And this actually posed many challenges to two kinds of judicial independence. One is the institutional independence, and the other is behavioral independence, the personal independence of judges while operating in a context shaped by conflicts. So they are trying to understand, the question is that how do they see that conflict? How challenging and is that, and how you cope with that conflict happening outside and affecting the court from outside towards the judiciary? Yes, either of you, Honourable Justice Barito Suarez or Dashutin, whosoever wants to answer. Yes, go ahead, please.
Thank you. Yes, our country, it's a country with some problems because many government and some political parties have attacked several times the judicial system, both the Constitutional Court and the Council of State, because we have a rule to protect our legal system and constitutional system against the power of the government. As I mentioned in my presentation, we have declared some measures against some decrees issued by government, and it has been a problem for us because government reacted in a bad way, attacking us and attacking the legal framework. Obviously, our duty is to protect the law and act in an independent way, just to assure the rule of law. We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution, and that is we have done. Thank you.
Thank you very much. The Honourable Justice Ehud Dashutin from Supreme Court of Ukraine, would you like to respond to that?
Thank you for a question. Administrative Cassation Court, it all depends on the organization of each judge's work. The war affected the judiciary, but judges had already adapted and working in a difficult condition, but access to justice is ensured. I want to say thank you for support a European country and other country for supporting in these difficult times for us in times of war. And I want to thank you for the invitation and for supporting our country in these difficult times, and our justice system is trying to adapt during the war.
Thank you. I think we have questions, but in the interest of time, I think it's better I if I make concluding remarks, what do you think, Justice Kari? Is that okay for me?
Absolutely. Please go ahead.
Distinguished Chief Justices, Honourable Justices, esteemed colleagues, friends and participants from across the world, as we come to the close of this remarkable North-South judicial dialogue, I would like to begin with a profound sense of gratitude. What we have witnessed today is not merely an academic discussion, nor simply a series of formal interventions. Rather, it has been a genuine conversation across jurisdictions, traditions, and continents, an exchange that reminds us that the rule of law is both a legal principle and a shared human aspiration. I would first like to extend our deepest thanks to our distinguished guest speaker, the Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland. Justice Kuusiniemi's lecture invited us to reflect seriously and courageously on the phenomena of backsliding of the rule of law, a challenge that transcends geography and political systems. His thoughtful insights reminded us that institutions alone cannot safeguard the rule of law. It ultimately depends on the integrity, independence, and courage of those entrusted with judicial responsibility. Just so you know, while you were delivering the lecture and other discussants were sharing their comments, I've been receiving different comments through email appreciating the survey. According to them, it was a survey of developments in different parts of the world regarding backsliding of the rule of law. So really appreciated your lecture and the comments from discussants. We are equally indebted to our distinguished discussants whose reflections enriched this dialogue with perspectives drawn from their own constitutional and judicial contexts. My sincere thanks to the Honourable Justice Dilip Nawaz of the Supreme Court of Sri Lanka, the Honourable Justice Dr. Omar Joaquin Barreto Suarez of the Council of State of Colombia, the Honourable Justice Ihur Dashutin, President of the Administrative Cassation Court of the Supreme Court of Ukraine, the Honourable Justice Igor Strupis, President of the Supreme Court of Latvia, the Honourable Justice Ivo Pilving, Chairman of the Administrative Law Chamber of the Supreme Court of Estonia, the Honourable Justice Professor Dr. Andras Vargas, President of the Curia Supreme Court of Hungary, the Honourable Justice Francis de la Porte, President of the Administrative Court of Luxembourg, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourable Justice Martha Koum, Chief Justice and President of the Supreme Court of Kenya, the Honourable Justice Dimitri Karbarov Ayuda, Vice President of the Supreme Court of Spain, and the Right Honourable Datuk Seri Utama Wan Ahmad Farid bin Wan Saleh, Chief Justice of Malaysia, and also all those who wanted to participate and they were very much keen to contribute to this discussion, but due to one reason or another reason, they were not able to participate. These judges include, but not limited to, the Supreme Court of Israel, the Constitutional Court of Palestine, the Chief Justice of Norway, Switzerland, Sweden, and many more. Your contributions have demonstrated something powerful, that despite differences in legal systems and constitutional cultures, there exists a common judicial conscience, a recognition that the rule of law, once weakened anywhere, is diminished everywhere. The theme of backsliding invites not only analysis but also introspection, and it asks difficult questions of all of us, judges, scholars, practitioners, and citizens alike. Are our institutions resilient enough? Are we sufficiently vigilant? And perhaps most importantly, how do we ensure the rule of law is not merely proclaimed in constitutions but lived in practice? And how do we see the difference between the rule by law and the rule of law? Today's dialogue reminds us that safeguarding the rule of law is not a solitary task undertaken within national borders. It is a collective endeavor. Judicial independence, accountability, and integrity are strengthened when courts speak to one another, learn from one another, and stand in quiet solidarity with one another, especially in the context of political and social conflicts. This is precisely the spirit in which the Global South Network was created, to build bridges of dialogue across jurisdictions, to encourage mutual learning between the Global South and the Global North, and to create spaces where judges and scholars can reflect openly on the pressing legal challenges of our time. I am deeply grateful to all our distinguished speakers and participants who have joined us today from different time zones and legal traditions. Your engagement demonstrates that the defense of the rule of law is not confined to courtrooms. It lives in conversations such as this. As we conclude, I would leave you with a final reflection. The rule of law is not merely about the behavior of judges. Judges do not have power of guns, firearm, nor they have power of the purse. In the end, it is the public support which is the main source of the courts, and especially their enforcement of those decisions that could be very challenging for the other branches of the government. They are not necessarily expected to express this support in form of protests or strong statements, but this support can also be expressed in form of active participation in these kind of dialogues which we had today. May today's dialogue strengthen that shared commitment. Thank you once again to our distinguished guest speaker, our eminent discussants, and to everyone who has joined us for this important conversation. We look forward to continuing this dialogue in future events of the Global South Network Judges Guest Lecture Series. Thank you, and I wish you all a very good evening, or morning, or afternoon, wherever you may be joining us from. Thank you very much.
Thank you, all of you. Goodbye.
Bye-bye. Thank you for the support. Bye-bye.
Thank you.